Hello, my name is Jason Johnson with Johnson Litigation. I do personal injury, a major felony defense. Today I want to talk to you about depositions. First, what is a deposition? Well, in a personal injury case or civil case, a deposition is a discovery tool. Discovery is a technical term that just means just that. You're discovering information. There are many different types of discovery. There's interrogatories, or basically questions that get answered in written form. There's requests for production of documents where opposing side has to produce documents. There's requests for admissions, again, where they have to admit or deny certain elements of a case. And then depositions are basically where all the parties come, the person that is being deposed or the witness is placed under oath with the court reporter and is asked questions by the requesting attorney. That is a deposition, and it can happen in today's day and age. It can happen virtually. Depositions typically used to be all in person. Sometimes they're videoed, sometimes they're just over the phone. But today you can do remote depositions through the use of Zoom or other internet platforms. Is a deposition confidential? Well, it is under oath on a case typically that is been filed, that is public. Often these depositions are used in training as far as what to do right, what people did wrong, and ultimately it can be admitted at trial. So it is not confidential unless there are some specific reasons or stipulations that are made between the parties. Who is present at deposition? Well, the requesting attorney. So if I am filing suit against someone and I request to depose one of their witnesses, then I'm present as a lawyer. The witness is present. The witness's lawyer is present, or the opposing counsel. In some cases, we have multiple defendants. We have a case where there may be 4 or 5 or more defendants. And all of the parties in the lawsuit have a right to be there as far as the attorneys. Now, during that deposition, if I'm, as the attorney, taking the deposition of the witness, it is my deposition. I ask the questions. There's really no objections except one technical objection as to form, but opposing counsel can't be talking, can't be interrupting. It is my deposition. It is like a cross-examination without being in court and without having the other side ask questions first. How do you prepare for a deposition? If you're the one to be deposed, your attorney should do some prep with you. They should explain the process of what to expect. They should explain the issues that they anticipate that are going to be asked, and they should explain how to listen and answer the questions in a deposition. Trial testimony in general is different than conversation. Anytime you take the stand under oath, whether it be through a deposition or at a trial, you should be prepped by your attorney. Now, does a deposition help your case? Ultimately, that depends on how much preparation your attorney puts into the deposition. A deposition is a great tool in a case to narrow down testimony, to focus issues, to get the testimony that you need at trial, and to really lock in key elements of the case. For instance, if it's a slip and fall case, and as an attorney, I'm representing the person who's been injured, I want to establish that the premise holder or the business owner or the apartment complex, that they knew or should have known that there was a slippery substance there, that they did nothing about it, that the person did in fact fall. All of those areas by way of example, are areas that I would want to narrow down in a deposition. So at the time of trial, they don't become an issue. They're already established. Deposition is a key part to any civil litigation, to include personal injury. If you have questions about depositions or about your injury, please give us a call. We are here to protect the rights of the accused and to promote justice for the injured. Thank you.